welcome to Wealth Matters, where we discuss the opportunities and challenges of preserving and managing wealth. The show was presented to you today by Gaslowitz Frankel, a law firm dedicated to resolving disputes involving your wealth, whether through your will, your trust, your business, or your investments. For news, pictures, and tips, go to our website at gaslowitzfrankel.com or follow us on Twitter at Estate Dispute. Our show's hashtag is Wealth Matters. Your hosts today are Craig Frankel and Adam Gaslowitz. And today we're talking about the impact of real estate title issues.
And now it's time to introduce our guest. We're pleased to have with us today Hugh Wood, a partner with Wood and Meredith. And Wood is an expert in resolving estate and title issues. And Hugh, if you could just tell our audience just briefly what your firm does so we can...
We resolve land issues that come out of estates and out of partnership disputes. They're very similar, and clean up the title and try to give people insurable title that they can sell, developer's title. And the issue that we have this morning really are the disasters that come out of will distributions and intestate, which is where people die without a will and leave multiple fractional ownership in property.
And you litigate over these issues, right?
That's true. I don't plan, I litigate.
Okay.
That is true.
All right.
So let's just jump in. You say that you deal with the problems. Tell our listeners what the biggest problem you're seeing right now in real estate issues when we're dealing with inheritance and transfer.
Well, what has been both right now and over decades is fractional interest in land, that sometimes people think they're doing the right thing and it turns out to be a litigation nightmare.
Tell our listeners what fractional interest means.
Father creates a will and distributes the farm and the house, or now small commercial shopping centers, to his son, and two daughters, thinks he's doing the right thing, and they end up with a third, and then they don't get along, and the fractional interest is that where father owned the whole, or his business owned the whole, now the sister, the daughter owns a third, the son owns a third, and the other daughter, who lives in Alaska and could care less, owns a third, and then you get huge problems of how to continue the business or how to sell it or partition it.
Why is that a problem?
Because people historically for 5,000 years haven't gotten along.
So who controls the property? If father leaves a commercial real estate property to his three children, who controls that property?
Well, they in that scenario, they control it together. I mean, unfortunately, you get a three-way ownership. They have to agree on it. Honestly, today you have corporations, partnerships. You tend to get into an ownership. In the LLCs, which are different, LLCs started in 1977 in Wyoming, and they were recognized in 1994 in Florida by the IRS. And you have a different ownership because you have a managing member and members. And if the sisters or brothers are members, all the power goes to the managing member. And so many problems I see with fractional ownership come in these LLC issues.
Let's back up and kind of divide it up. So I'm a patriarch and have lots and lots of children. This is a fiction. And I own lots and lots and lots of property. And I give it to my 14 children with, and what is that called? Is that called tenants in common?
Oh, yeah.
Okay. And my 14 children actually do get along. How do they actually make a decision? Because I think this is the problem. Does it require unanimity? Can they just have a vote? What happens?
Under pure tenants in common, any one, it's just bizarre, any one tenant in common, at least in Georgia law, and it's similar in other states, any one tenant in common may possess the whole, may collect rents for the whole, may keep them, but they're subject to, and almost no one sues over this until you hire someone like me and we go in to start to figure it out. They have to account for the other 13, 14, the other, in your hypothetical, they have to, say they're getting $1 million of rent and one person's keeping it. Actually, it's pretty common, especially if you have lots of houses that have tenants. One of the things in this fractional ownership is they go steal the tenant money.
And of course, you got to have a contract with the tenants too. Well, how do you sign a contract with 14 co-tenants?
They tend to violate the law, and one co-tenant gets the signatures. The way you would do it is you would have to have them all, or they would have to have an agreement.
By violate, you mean inadvertently? Because most people don't really know they've got to have everybody who owns the property signing off on the
In my lawsuit, some do it deliberately, but yes, a lot of people do it inadvertently.
But you're certainly going to find it when you want to sell, because now you're going to need everybody's approval.
The selling, usually what drives the lawsuits is a developer offer, is a cash offer, is some value to the land. Now, in a lot of rural areas, not to disparage them, some land is not worth the dynamite it takes to blow it up. And in divided ownership, I've explained to many families that the land's only worth $800 an acre. Why don't y'all just settle it? Just resolve it. Go to mediation. So, it's not worth the litigation. You have property in North Atlanta. I got an offer for fractional interest this past weekend that is probably going to resolve the litigation. What I said to my client is, you better have signed the letter of intent by the time I get back to Atlanta after the holiday.
You said that you had an offer on a fractional interest. Can one tenant in common sell his or her interest without someone else's permission?
No, they can only commit their own interest.
But they can sell their undivided interest. They just can't give.
Almost no one will buy it.
That's the problem.
Now, in hostility, I have actually, on behalf of clients, gone in and purchased for a client the half interest or whatever to begin the litigation to get the whole.
And when we talk about my 14 kids owning this property, what if my kid in Alaska wants out? How does he get out?
Let's say
more
4. Realistic with 5 or 6.
Okay, let's say 5. How does my daughter in Alaska get out if she wants to get out without the other people agreeing?
You have generally in all states, Georgia, it's called partition actions. You have to bring a special in the plenary court, in the court that has the jurisdiction. Most courts are circuit courts. We have superior courts. You actually file this really long, complex, messy lawsuit where one person says, I want to sell it. I want my money. And they own a fifth. And you go through this statutory process, which is way too long to explain here, of valuing the money and then having the court either divide it up by sale or going to the courthouse steps, which is very frightening, and have what's like a foreclosure sale. And this works in other states the same way. And you push it off, sell it, and divide the proceeds. You divide the cash. You ultimately have to turn it into cash.
If you do that, can some sell and not others?
Under our statute after 1983, no. In most states, or no. Some state, under Old English common law, yeah, you actually can. The problem with a partial ownership, which comes down through these wills or comes down through inheritance, which is dying without a will. Lots of people die without a will.
And if you get property, if you die without a will, you're going to get a tenant in common interest, whatever that is.
That is correct.
And just to highlight for our listeners, one of the problems that we face is that somewhere along the way, after they've inherited, somebody else dies and they haven't solved the problem. And then somebody else dies and they haven't solved the problem. And now you really have a mess.
You have, I remember talking to your partner a month or two ago, and he said we have like 32 or 40 levels below in a sub, and I've encountered a lot of mess, but I have not encountered that.
Well, as you die and pass fractional interest onto your lineal descendants, you end up with teeny fractions of fractional interest.
There are many families in South Georgia who do no planning at all, and there will be large farms, 1,000-acre farms. The patriarch will die, then it will go to 4 or 5 children. They will do no planning. They will die, and you'll have a valuable piece of property you want to develop. It's usually the offer that begins to drive the issue. And how do you do it?
So let's go back. So you had said that that a fractional interest, it can happen through tenants in common. It can also happen through limited liability corporations. And you said that using an LLC might solve some of the management problems. Explain why that would work.
Well, you'd have to have, there's a difference between an incorporation, which is going to have its own bylaws and shareholder agreements, but in an LLC, which is much more common, you have an operating agreement. Now, unfortunately, a lot of people's operating agreements, they download off the internet, and it's one page and won't tell them anything. If you have an operating agreement that defines how the members of the corporation, which historically were stockholders in a regular corporation, you can take sister and brother and sister who you want to distribute the money to, and create an operating agreement that says, okay, you're going to inherit the shopping center, the LLC is going to run the shopping center, and we're going to use the operating agreement to live on. And corporations have theoretically eternal life, so that will continue past daddy's death.
And just to be clear, you're talking about a situation where everybody agrees, either everybody agrees to set up an LLC and put the property in it, or the patriarch or matriarch does it before they distribute it down to the next generation.
It's usually the former. It's the matriarch, the patriarch. Now, one of the things that I don't know, kind of going off a little bit, is these family trusts have shown up in the last 10 or 20 years, and they operate, at least in terms of management of the corporations, kind of the same way.
The trustee kind of takes control.
Yeah, and I got one recently, and I haven't even counted up how many trusts and sub-trusts they have. They have property in Florida, they have property in North Carolina, and they had a main trust that was created through a leveraged buyout. They've got multiple sub-trusts. I mean, but it will run. One thing that, because you have the trust documents, you get out of my world where I earn money on most of the litigation that my firm does in resolving the real estate comes from the non-planning. For the folks who are listening to this out in the distant internet land, plan for what's going to happen to your property. And if you can just spot that your children are going to fight, trust me, the divorce of the dead occurs if they don't like each other, then plan for that. Also, you'll find, what I see a lot is that one person will be a doctor or a developer or have this career, and then there'll be other people, like your hypothetical of the girl in Alaska, that doesn't care. Some don't even care about the money, but mostly they just say, I want my money, I don't want to come back, I don't want to live there, I just want my money.
So I want to distill something.
So for a simple example, just to make this clear, you've got a father or mother have a vacation home. They want to leave it to their kids. They do no planning, so they leave the vacation home to their 3 kids equally. They all have equal rights to the property. They've all got equal rights to possess it, right?
I've got at least 2 or 3 of those
and without
cases right now.
So without any agreement, anybody can go to that house unless they can agree among themselves. They can all show up. They can all occupy the house. They can do what they want with
And who pays for it?
They all have to pay for it in thirds. I mean, I've got one where the parties actually agree, and the former executor, because it got set up, the executors just lived on and managed and taken the bills and paid it. In one, I mean, I know you're looking at planning. In one, Cashiers and Highlands have a lot of vacation home properties around this area. Hey, that's in North Carolina. They actually have the weirdest organization. It's owned by multiple parties. They keep a checklist of almost like timeshares of who's going to live there. That's a terrible way to manage the property, because now, as they're getting older, one of them wants to sell, 2 or 3 don't want to give up the vacation home, and that lawsuit is brewing.
So
hadn't been filed yet.
Let me distill a little. So the first thing you're saying is, don't fall, if you own real estate, whether it be Georgia or not Georgia, don't fall in the trap of just letting it pass without a will.
Absolutely.
Do planning. And one of the ways to do planning might be a real estate trust, but a logical way is a limited liability corporation. At least you can now control it.
Well, if everybody did that, I need to get another job.
Well, we're going to try to stop. Now,
I think you're safe there.
Let's look at these LLCs. Don't you also have to make sure that you've actually answered some of the problems? For example, how does somebody sell? Does somebody have veto power? How do you make decisions? Is that something that you can control in an LLC?
If you do to make an analysis that may be a bit above, a will or the statutes in whatever state people are in, Tennessee, Georgia, Texas, the state code will provide anything that's missing in the will. If the will is valid, then it will have terms. I'll answer your LLC question in just a second. So all of that stuff will work if you bring the code onto the will. To do it in LLC.
But that may not be really what the decedent wanted.
It's a mess. I had one, 4 mineral properties and interests and cash and minerals in Texas and Oklahoma and Colorado, real mess. In the LLC, because that's what you're coming back to, you're going to have, and you should get a law firm to do this. You're going to do the same thing in the operating agreement inside the LLC that you would do with the terms of a will. This is all relatively new. I mean, if you look at law as it develops over 200 or 300 years, the issue of LLCs is within the last 20 years. I mean, you could do it with Incs, you could do it with corporations, but LLCs are so easy to set up. Dwight, we were once borrowing money for a client, and the bank said, we can only do this if y'all have an LLC in the trunk of your car. My partner turned to me and said, well, Hugh does. He's got a whole bunch of LLCs already pre-made in the trunk of his car.
But if you set it up as an LLC in the parent's generation and put the property into the LLC,
it has to be in the it's generally not. The children can do it if they agree. They could create an agreement and do that. One problem with LLCs, a real problem, is that the way state law works is that the managing member, this is not true of corporations, the managing member of an LLC has very substantial power over minority interests, so that whoever you're going to empower in the LLC is the power.
And you may want to have provisions to solve that problem. So when you go to the lawyer, find out what they want to do and what's kind of standard, but also talk about your family and how they would deal with a problem if it came up, and talk to the lawyer about the solutions, because solutions can be included.
In the LLC, you can create anything within reason, anything that's legal, in the operating agreement to resolve. It's a contract, and it will say, here's all the property we own, here's the method by sale, here's how you want to sell it, here's the people. You have to have a majority interest or not. It's up to you.
You're listening to Wealth Matters, the radio show where we discuss the opportunities and challenges of preserving and managing wealth. We're your hosts, Greg Frankel and Adam Gaslowitz, from the fiduciary litigation firm of Gaslowitz Frankel. Today we're discussing the impact of real estate title issues. Let me go back to the LLC issue. If the parent generation takes property and puts it in an LLC before they distribute it out to their children, there's a basis issue, is there not? Don't they lose what?
By basis, you mean a tax issue?
A tax issue.
You bring the basis of the property into the corporation as where it is. Now, they tend not to sell it. I mean, let's go over and draw the comparison in the non-LLC, because that's where I think that the audience needs to see the issue. If the patriarch dies and has, in fact, this is one that I had, and bought the property in 1959 for $60,000, and then we get a $4 million offer to sell it in the year 2012. Under our current inheritance laws, you get a stepped-up basis. There's no gain.
And what does stepped-up basis mean?
That you ignore, because the government is so kind to us, you ignore the taxes on the difference between, let's say, a $60,000 purchase in 1959 and a $4 million sale in 2012.
So in other words, when you die, the value of the property is the value at the date of death.
That is correct.
Which reduces taxes in theory.
It eliminates taxes.
Okay.
Okay, and one problem, since you're talking about what not to do, hello out there, don't do this. Say you have three siblings, and mom she wanted to solve the problems, so she deeded the property in 2010 to one of the siblings, saying, well, we're here to solve all our problems. We won't have this LLC problem. They missed the stepped-up basis. So all of a sudden, we had a gain between $60,000 and $4 million, which we had to pay tax on. Had they died and gotten mama's stepped-up basis, zero tax.
So one of the questions you need to ask your lawyer when you're doing your estate planning is, how is this going to affect me, whether it be an estate tax or really right now, whether it be a capital gain tax?
Yes.
Okay. Now take us to the LLCs. What's the difference?
You can generally you keep the basis in the LLC.
So if you own property in an LLC when you die, does the property get a step up in basis?
No.
Does the LLC get a step up in basis?
Is there any way to accomplish that through an LLC?
Not that I'm aware of.
So really, when we're talking to our listeners, one of the key issues deciding whether to use an LLC versus a trust or something else, or through inheritance, is talking about the tax ramifications. That's what-
Absolutely. And I tend not, because I don't do the tax planning on the front end, I tend that these issues come to me. And by the way, even though we continue to talk about the LLCs, I see that rarely. I mean, in other words, the disasters that come, that's planning, and the planning is not there. What is more common that is people misplan with these new family trusts, although that is money. They misplan with disastrous real estate trusts. Dear listeners, please don't go download things off the internet and dump your property into internet real estate trusts. Just total disaster. Or
By the way, that's an advice for virtually everything dealing with transfer, whether it be a real estate trust or a will. We see wills and trusts that left things off that create absolute weird results that end up litigating over that no one wanted. Use a lawyer.
I probably have lost count of the number of downloaded wills that people use to skip paying a few $100s to a lawyer and create literally hundreds of thousands of dollars of disaster for their family, because as you indicated, the will's a complete mess.
Let's switch topics. A lot of our listeners, hopefully, have houses and vacation homes that may not be in the state in which they live. Does that create problems?
Well, we're not supposed to talk about technical terms, but it creates a problem of ancillary probate.
What does that mean?
That means that if you fall into the evil world of probate, that the will is generally docketed in what's called the domiciliary state, or the state where the person who wrote the will dies. And then that estate has the jurisdiction over the will and over probate. But if the land is in Florida or Alabama, I believe California is mandatory, when you want to go sell that vacation home or sell that property, Florida has a statute, Florida Statute 734, that you have to open an ancillary probate in that estate to resolve this issue. And if you had planning, you could do it through a trust, or you could do it through an LLC and skip this whole issue. But if it's probate, then you got the probate in the first state where the testator dies. Then in mandatory states, you then have to open a little estate probate and do it. And one of the issues,
and that's just so you can transfer title to the property.
It's generally always real estate. It does have issues with investment accounts, but 99% is always dirt, is always the vacation home, the condominium, the property. You tend not to see commercial properties, because commercial properties are more designed with incorporations, and I tend not to see operating commercial businesses in this. This is always the fruits of daddy's labor, mama's labor, that is then off to the children.
So if you got property in other states, you have a vacation home in North Carolina or Florida, is there any way to avoid the probate that you'd have to go through in that second state when you try and distribute the
if it's a mandatory ancillary probate? No, in Georgia.
If you take the property and put it in, say, a revocable trust, would that
you
avoid
can do that.
Okay.
You can use a revocable trust to skip probate.
So properties that you own in other states, if you live in Georgia, for example, and you own property in Florida, if you have that property in a revocable trust, then the
you
property
can skip it. Most of these, and you know this, most of the provisions of revocable trusts become irrevocable upon death.
Sure.
And so then if the kids think like, oh, we could do what we want with the house when daddy dies, the vacation home in Sarasota, Florida, which is one, you all had one in Naples, I know we dealt with, that when it becomes irrevocable, then you get into the trust litigation.
But at least there's somebody that is identified who's going to control it. It's going to be whoever is designated as the trustee.
True. Now, there is a problem that we deal with in many states, is that you get on a parallel track where you're litigating the trust in the Superior Court and the probate court has the wills, and that's just unresolvable.
Okay. What about property that is in community property states? A lot of people move here from, say, California or other states where they might have community property.
Georgia's a title state. Most states are title states. Louisiana, Texas, New Mexico, Nevada, California, skip Oregon, Washington, Alaska's an opt-in state, and Wisconsin, God knows why Wisconsin are community property states. Those are the community property states. It's almost like the old Spanish curve from Mexico or community property states. Everybody else is a title state. If you inherit community property state, it overcomes. In Georgia, we have a statute that says if you bring separate property to the marriage or whatever, it's your property. Community property state, you have to account for the joint ownership.
And so if you die owning community properties, what happens?
There is a presumption that your spouse owns a part of it.
Okay. Even if you die in Georgia?
Yeah, when the ancillary probate, you're going to get that issue in the ancillary probate in California.
What happens when you, if you own property jointly with, say, a spouse and you have debtors, people that you owe money to?
They always do.
All right, so you have a creditor, you own property jointly with your wife. You default on a debt that you have. What right does the creditor have to go after jointly owned property? You
get into to some of the issues that we started with on tenancy by the entireties, joint tenants, the right of survivorship. We don't have a death situation. Would you have a death situation here?
Well, even without a death,
if
you and your spouse own jointly owned property, and you have a creditor,
the creditor can levy on all of his tenants in common. I mean, they have to account for the other half of the interest in a sale.
So in other words, they would sell it, they get to keep half towards the debt, and the other half would go to the other owner.
And I did and still do a fair amount of litigation in foreclosure, and one of the big surprises to lenders, which is a great defense for us, is the lender goes to foreclose and finds out the wife never signed any of the documents, and at the end of the foreclosure they have a half interest instead of a whole interest, and it allows us to really negotiate against them. Although some states are better. Florida is much better to suffer a foreclosure than Georgia. Georgia is unfortunately lenders' paradise, and there are few defenses to a foreclosure from a lender. The lenders
say that again and explain it, because I think that's a big deal.
It is a big deal, and it is a real hammer. Georgia is a very lender-friendly state. We also just eliminated the Depression era deficiency where you can challenge for the amount of money of a foreclosure. There are almost no defenses once you get into foreclosure. It's very hard to stop. Only Chapter 13 or Chapter 7 will stop a bankruptcy. Theoretically, and I've done some of it, you can go get a TRO. It doesn't work. It's only good for 30 days. You have to get a permanent injunction. Mostly you have to pay the money into court. If you could pay the money into court, you wouldn't have the foreclosure, so it's kind of circular. If there is a half interest that is not signed in this, which occurs, and it's usually either the husband didn't sign or the wife didn't sign on the security deed, which are trust deeds in other states. We have 4 methods of securing property in Georgia. Then when the bank foreclosed or the lender foreclosed, and a lot of these are private foreclosures, the 50% remains out there.
Prior to the show, we were talking, and you said that one of the big risks was obviously the foreclosure that you discussed, but also failure to pay taxes and what happens on tax lien.
You could do an entire show on taxes. I mean, you're talking
about property taxes now.
This is real. This is ad valorem property tax. This is not your income tax, not your capital gains tax. It's not what you file in your 1040. These are the county property taxes that always travel with real estate. In, as far as I know, every county in every state. They're always there. And the mechanisms work differently. If you fail to pay the property taxes, over time you can lose it. And in Georgia, if first you get a FIFA, you get a levy by the county, then it eventually gets sold, and you have a year redemption period. If you don't pay it, you lose it. And also all the issue that I think that is important, what we're talking about here, all the co-tenants lose, all the heirs lose. It's not a fractional loss, it's a complete loss. So everybody loses. All of those 14 heirs that you were talking about, the tax issue will clean the property out like a foreclosure, and the property's gone. So, and it's really the only reason that banks require, if you think about it, banks require an escrow on, why is it they require an escrow? Because it's the only thing, really, except for a federal tax lien, that can get in front of their first lien and kill you, and kill them.
So,
got to pay your taxes.
If you have, well, in Georgia, I don't know about other states, in Georgia, other people can come in and pay your taxes, can they not?
Yes.
And essentially buy your tax lien.
Vesta and Proctor have been, well, it started in 1985 in Georgia. And yes, people come in and pay the liens, and then they step into the shoes of the county. They have the same rights paying the liens. Only 2 counties in Georgia allow the sale of what's called the FIFA or the levy. But in the sale on the courthouse steps, and this occurs in Florida, this occurs in Alabama, it occurs in other states, that once it's sold, it goes to the other parties. Now, we're a very harsh state in Georgia in terms of redemption. Florida, I believe, has a 36-month.
When you say redemption, what is that?
That means that after the sale occurs, all is not lost, that you have to go pay the taxes plus a 20% penalty plus a 10%. There are lots of penalties to get your property back. So say if you owe $15,000, $20,000 of unpaid taxes, you might be in a situation that to recover your property, you have to pay $40,000 to the pirates who bought it to be able to recover it to the family. I don't know what to call folks, in disorganized families who tend not to write wills, much of the property that is decayed or delinquent simply disappears in tax sales.
Yeah, we see a lot of that.
Very common.
Yeah. You're listening to Wealth Matters, the radio show where we discuss the opportunities and challenges of preserving and managing wealth. We're your hosts, Craig Frankel and Adam Gaslowitz from the fiduciary litigation firm of Gaslowitz Frankel. And today we're discussing the impact of real estate title issues. Let me follow up on one thing I started to ask you a little earlier. With regard to jointly owned property where one of the owners of the property has a debt, if that person dies, the property passes by operation of law to the surviving joint property owner. What happens to the debt? Does the creditor still have the right to go after the property?
Yes, and it depends on, you can only sell or mortgage up what you own. So if the other tenant's in common, the other fractional owners they're not subject to that. So if the lender sells the property, the lender can sell the property.
Well, so assuming that before the lender has done anything, the debtor dies.
And there are other people who own it who are not committed to the debt.
Yes.
Okay.
Husband and wife own a piece of property. Husband has a huge credit card debt. They have no other assets. Husband dies. Property passes to the wife as the joint tenant. What happens to the credit card debt? Can the credit card company go after the property or the husband's half of the property that he owned before he died?
Well, in the analogy you posed, credit card debt has to go through a judgment. You can't, because it's generally not secured by the property. It means the property doesn't stand for that debt. Credit card debt has to travel through a judgment lien. Then you levy on the property and sell the property. Almost you never see that through credit. What you see it is secured debt, that the property is set up for secured debt. One or two parties in your interest won't have signed that debt. The lender can sell it, but the lender has to account for any excess proceeds. Sometimes there aren't excess proceeds, has to account for the non-sale interest. Now, in Georgia, as you and I well known on other cases, after 1981, you don't have to foreclose on the secure property. I think it's Thompson v. Watkins. You just go sue on the promissory note. So a lot of lenders, if they get frustrated about this property issue or this fractional interest, they just sue on the promissory note and go get their judgment levy.
Now, if you have a judgment levy, can you take the property even from the co-tenants who didn't sign the deed?
Yes, but you have to. It's always like, imagine that the property theoretically gets turned into a pile of cash. So you have to account for, you can take what you're owed by the people who sign, and you have to account for the other interests that you don't have. By the way, it's not really common. It does happen. Some people do it. It generally arises if there's lots of equity. We've got one right now where the debt's probably 80 or 90,000. We are in a pitched battle trying to stop that, and the equity is probably 400,000 in terms of the huge growth of the value of the property, and the debt is driving. The equity is driving the lawsuit because nobody planned for it.
Does it matter whether the debt is associated with the property? In other words,
Absolutely.
you gave a security deed to buy the property versus you gave a security deed for another loan to buy
well,
a
we're technical. What's a security deed? No, I mean, I know, but I mean, do you mean like a mortgage or a trust deed, or you set up the property for that? Absolutely. When the property is pledged, the real estate, it's always real estate, is pledged for this instrument, which in Georgia we call security deed. In North Carolina, Virginia, I'm licensed in Virginia. That in all these other states, it's a trust deed. Almost always they go chase the property by foreclosure or by levying on it or selling it.
So what happens then? What if I own a piece of property and Craig is trying to take out a loan? He has no collateral, so I offer to use my collateral for his loan, and he defaults on the loan. They'll obviously
the answer is don't.
Well,
the answer is don't.
Sure, but people do, and we've had clients who have done that. So the lender is going to come and take the property because that was the collateral, but Craig is still
really
obligated
kind
on
of what you posed is, and these are very scary, and these are also planning issues. People do not please do not become guarantors unless you truly understand what you're doing. I think
we can agree Adam did not understand.
No. I'm talking to the audience that what happens is a daughter will need money for college or need something, or they will go and father or uncle will just think like, well, there's no big deal, and he will sign a personal guarantee, first backed by the property, then backed by his assets. I've been to the Court of Appeals numerous times trying to get out of that. The lender guarantees are brutal, and they're also in other states.
So the lender can just go against the property because that's the way it chooses to do it.
Yeah, but then what they do with the guarantee, usually because they're personal guarantees, is they then begin to invade other assets to make them whole because the debt exceeds the property. And those lawsuits are just ugly beyond ugly.
Let's ask the question kind of differently. So Adam did, in fact, guarantee me for my personal loan. It gets foreclosed. Can Adam then sue me to get the money back?
Yes, but because you're broke, because you went through the judgment issue first, I mean, it's sort of a nonsensical circle because it would have been paid in the litigation. Yes, the answer is the law provides a remedy. The remedy is he can sue you. Will it actually occur? Will he get the money? No.
Well, in that situation, perhaps it doesn't make any sense. But we have seen situations where someone secures someone secures someone else's loan with their property. The person who they're securing the loan for makes payments on the loan and then dies. So
Right.
the loan wasn't in default until they died. Now someone takes over their estate and they don't pay the loan. So my property gets foreclosed on. At that point, there's probably assets in the estate. I can go after the estate to collect on the debt, right? It's not my debt. It's
Based on the way you
decedent's debt.
pose the question, yes.
Yeah.
Let me kind of shift the questions a little. We talked about property that's outside a state. Some of our
You mean a state of the union, not an estate?
correct.
Okay.
And now, what about property that's owned in another country? Does that create different issues?
Yeah, and mostly it falls into an area of conveyance. The only reason that we would pose this is you have someone in the United States that wants to deal with transfer and you got a death out of the country. In ancillary probate or in a Georgia probate versus Minnesota, Georgia, and Alabama, to sell a piece of property, you need the deed. A deed has to have the person who's selling plus two witnesses, and one is generally a notary, but you can have an unrecorded deed with two witnesses. And if you're coming from another state with probate, you attach the sworn probated letters testamentary, which an executor gets, and generally the will, and then you can convey. There's a statute under Chapter 53 and Chapter 44 in Georgia. You can convey the property. Little different in the foreign country. If you're dealing with organized foreign countries, the United Kingdom, Canada, Australia, not a big problem. You follow their procedures. You get not only the probate material from that country, but you have to get, under our statutes, you have to get the local court who has control to say, they put a special seal on it and say, we are the court in Queensland over this probate. They did it correctly. We stamp it. You have to have that additional certified copy of the federal to then put on our records to convey the property. That's really the only difference.
One last question. What's the biggest real estate problem, mistake that you've seen in your career?
The 7,000 acres of Georgia marble where they conveyed it to 10 fractional interests of the entire marble belt in Georgia with underground value and timber value and sort of the non-planned. It's a lot of times the patriarch doesn't want to give it up. And so it just happens by operation of law, and suddenly 10 wealthy families have a lot of value, a lot of timber. We haven't even talked about timber. Underground mineral rights, surface mineral rights, and there is absolutely no way to resolve it outside of lawsuits. Oh, another issue that you can do on some of these, and particularly in the LLCs, and this is relatively new, is arbitration clauses. And it's developing. I mean, it really is just
as a way to have impasse resolution to solve a problem when it comes up.
Right, and the arbitration, I've had good results that arbitration will take you into a 3 to 6 month resolution instead of our 4, 6, 8, 12.
So
one case lasted 17 years.
So what we're hearing is use planning, and when you use planning, put in impasse resolution to help you when there's a conflict.
Yes.
My very last question. Audience wants to get in touch with you. How do we get in touch with you?
Go to my website, www.woodandmeredith.com, or call me at 404-633-4100 in Atlanta, and be glad to talk to you about estate, mostly real estate title issues, planning, creating a will, what happens if you have a fractional ownership, and how to stay out of court.
As we are wrapping up our show, I want to thank everyone for listening to Wealth Matters, where we discuss the opportunities and challenges of preserving and managing wealth. For more information about Gaslowitz Frankel, please go to our website at gaslowitzfrankel.com. And remember to follow us on Twitter at Estate Dispute and use our show's hashtag Wealth Matters. Our guest today was Hugh Wood, a partner with Wood and Meredith. Please join us every fourth Wednesday of the month at 8:30 a.m. here at Wealth Matters on Business Radio X.